litigation risk exists in every civil case, and no matter how strong your claim is, there is always an appreciable risk that you might lose, and it does happen.
Welcome to Off the Record, a podcast on all things law for businesses in Queenstown. My name is Alice Milne, and I'm a senior solicitor at Mactodd Lawyers.
My name is Scott Donaldson. I'm a senior associate at Mactodd Lawyers. Today we've got a really fascinating topic for you. It's civil litigation and civil disputes. We've got a fantastic guest joining us who's going to talk us through some of the things that you might expect if you find yourself in a civil dispute and some of the strategies you might use to navigate that. So welcome to the Off the Record podcast, Damian Chesterman.
Thank you, Scott, and thank you for your kind words of welcome.
That's awesome. Damian, tell us a bit about yourself, perhaps, and how you found your way to Queenstown.
Yes, so I'm a barrister. I've been practicing for over 20 years. I started off in Auckland and then I worked overseas for 10 years, came back and I've been at the bar for over 15 years. And my son is a ski racer, and so we have been spending quite a bit of time in this area. Lived here for 6 months last year, 4 months the year before. So that's why I'm here in your offices at the moment.
Yeah,
good stuff.
Damian, I can't help but feel you're slightly underselling, well, not slightly, you're underselling yourself a long way, because you are a very experienced barrister representing clients in very high profile cases. You've been a litigator for almost 25 years, I believe.
Yes, that's right.
And one of the cases we just talked about earlier was a situation where you sued Gordon Ramsay.
I did indeed. So one of my cases after I returned from overseas was acting for an events company called Juco. And Juco would import to New Zealand celebrities to have dinners, charity dinners, and there'd be 1,000 people at each of these, and Gordon Ramsay was invited, and I can talk about it because it was publicised at the time in the newspapers, but he didn't come to the events, and he didn't make the first one or the second one, and so the client sued Gordon Ramsay, and we in fact ended up having an 18-hour mediation with Gordon. So he flew to Auckland, and we had it in a building on Shortland Street.
Yeah.
And it worked out well for everyone, and it was a very memorable case in my career, and I have a long-term relationship with that client.
I've got to ask you, did he swear at you at any stage during the mediation?
As I have to say, everything that happens in a mediation is confidential.
Glad to hear.
So this elusive mediation, Damian, what a lot of businesses probably, a lot of businesses will come across a dispute at some stage during their business tenure, and a term is thrown around, and there's potentially a lot of misunderstanding about what mediation actually is.
Yes, so mediation is a settlement process, and it's voluntary. Both parties have to agree to it. And they appoint an independent and neutral mediator, and that person will help the parties reach an agreement between themselves. So one of the common misconceptions, I've heard people leave mediations, or they've been at one before and they'll say, oh, the mediator decided in our favour, but they've misunderstood the process. The mediator doesn't make a decision. The mediator simply helps the party reach their own settlement agreement. And it works really effectively. So my personal experience is that around 70 to 80% of my cases that go to mediation will settle at mediation. In fact, it just happened last year. I'd been acting on a case for 2 years, and it was a vigorously fought case about a development of farmland. And the developer was claiming a couple of $1 million. The parties were at loggerheads. We'd been fighting bitterly for 2 years. Didn't think there was any hope of settlement, and that happened. So it's a positive thing.
Yeah. And what role does mediation have to play, in the context of filing in civil courts and there being backlogs and, waiting time for hearings. Mediation surely must come to the fore and allow people to resolve them effectively and much quicker than litigation.
Oh, definitely. I think mediation is something that it's almost obligatory as a barrister to keep it in mind at all times with your clients. If you're in a dispute, one that's been filed in court, or even before you file your dispute in court or arbitration, you always keep in mind, is it possible we could settle this before we spend more money on court? And you're right, it could be one way. There are massive what is the word? Backlogs? Backlogs,
yes. I think
yes.
I used that word.
Case overloads at the moment in the courts. And I think mediation would be a superb tool to resolve that. And one thing which we've touched on already is it's surprising how cases settle. You think there's no point of possible agreement between the parties, but once you've got them sitting together in a room, talking and listening, it's amazing how things do sort themselves out.
Yeah.
What if, in my experience, what I see is people getting themselves into dispute and they are damn sure that they are right.
That's right.
And if I'm in that situation, let's say I'm a landlord and I know that my tenant has breached the lease, I know I'm right, really I'm in a bit of dispute, and what I really want is to go in front of a judge, and for that judge I'll lay out all the evidence and that judge will say this person's right and this person's a dickhead.
Yes.
So if I'm in that situation, why would I want to mediate? I know I'm right.
Yeah. It's a really good question, because I think it is a common feeling when you believe you've got right behind you, you've got the law, you've got the facts. Why would you settle? And the big reason, well, in fact, in the landlord example, because I have acted for landlords, I did some cases for Robert Jones Holdings in the GFC. There was some abandonment of leases on Queen Street. The landlord has different considerations, but the first one I want to mention is the cost of litigation. If the landlord is owed rent, which is increasing monthly, I don't know what that rent would be, but I can tell you it's going to be nothing compared to the cost of litigating, because litigation is so expensive. So I suppose that would be a big reason why parties would go to mediation rather than filing proceedings. Another issue is that if tenants are not paying, typically there can be a reason for that, such as a poor economy, and it's something that we're struggling with at the moment in New Zealand. And as much as the legal rights may be behind you, I think every business person has an obligation to take a look at the bigger picture and say, would I rather have a tenant in that's not paying full rent for the next fair while, or that I'm going to miss out on some rent, but at least they're not going to go under and they're going to stay there. So those are reasons, but the landlord can fully pursue their rights as well.
Do you think people have got a false conception about what to expect in a court proceeding, and that causes them to go into a dispute in certain ways? They're going into a dispute, they're expecting to be made whole again.
Yes.
And what I've seen is people don't have that experience whatsoever.
No, that's right. Well, I mean, you're right. And a lot of people, I think, base their preconceptions on cases on maybe the show Suits or Ally McBeal. And in those cases, magically, the instruction is received, and by the end of the episode, they're in court and they've got a decision. We never see the invoice for the case. And we never see any of the work done. And so cases are not like that at all. Typically, an instruction will come in the door, and sometimes I get briefs halfway through, proceedings have already been filed, but quite often I get them right at the start. I would say that an expected period before you might get through the courtroom door for a trial could be 2 years. You then might wait up to 6 months for your judgment to be released. Once the judgment is released, you then have rights of appeal. Those rights of appeal are automatic to the Court of Appeal. that process,
Yeah.
and then awaiting the judgment could be 18 months.
Yes.
Maybe if you've got a special case and you get leave to the Supreme Court,
Yeah.
you could have a further step of appeal, another 18 months.
Yes.
Now, the cost of getting just to the first trial stage, let's say it's a 5-day High Court trial, that could quite easily cost you $150,000 to $200,000 in legal fees, and disbursements about $50,000. So I'll just give you a bit more information, because in Suits and Ally McBeal, you never
Yeah.
saw the work they were doing. Magically, the solicitors appear in court,
Yeah.
they know everything, they cross-examine the witnesses.
Yeah.
It's not like that.
Boston Legal's the one that I.
Oh, Boston
that's my
Legal,
reference,
exactly.
yeah.
The reality of the situation is the case comes in, quite often thousands of pages of documents.
Yeah.
A statement of claim has to be drafted. That could cost $20,000 to $30,000, because you need to make sure you've got your legal courses of action right. You need to make sure you've pleaded anything relevant to evidence correct.
Yeah.
For example, if you're pleading a misrepresentation, you'll need to specifically plead the particulars around what was said, when was it said, where was it said, and who was there, so that the defendant can then respond to that.
Yes.
So in order to get to that level, you probably need to speak to a couple of the potential witnesses for the trial.
Yes.
Then you move on to discovery, and which is the exchange of documents and other information that each party holds that might harm their case. Then you've got an interlocutory phase, and what that is are pre-trial skirmishes, where, for example, you might want, the other side might be claiming privilege for documents, and you think they're wrongly claiming it. So you apply to the court to overturn their claim for privilege.
Yeah.
Or there might be a third party that holds documents, and this happens quite a bit. So there might be a third party who's not a party to the case. You have no right to get discovery from them. You have to go to the court and ask the court for an order to order the third party to give discovery.
Yeah.
You might want a freezing order over the assets of the defendant.
Yes.
So with these interlocutories, you could be looking at an extra $30,000 to $50,000 step.
Yeah.
Then you've got your briefing stage for trial. You'll talk to your witnesses. One thing I like to explain to people is, let's say you've got a brief factual witness, a 2-page brief of evidence. So that could quite easily take 8 to 12 hours of time.
Yes.
You need to contact the witness, find a convenient time to talk to them, interview them, take the notes, write up a draft brief, send it back to the witness, talk to them again, add in whatever they want or subtract from it, then get them to sign it. Then get them to turn up for trial, or prepare them prior to trial. They turn up to trial. So just one brief witness could add, $6,000 to $10,000 to your case.
Yes.
So by the time you get to trial, it would not be uncommon for the barrister to have spent 300 to 400 hours on your case.
Unbelievable.
And
Yeah.
then for each appeal step might be another 100 hours.
Yeah.
Something that a lot of clients don't appreciate is the emotional toll that has to
Exactly.
have something like that, holding on to that for a number of years. What impact that must have surely on the actual day-to-day running of their business. Like, they've got families at home, they've got businesses to run, and then they've got this court case to prepare for that they're not familiar with.
That's
that would
right.
probably keep them awake at night. I wouldn't want to give evidence in court, and
No.
I know what the court's like.
Well, in fact, halfway through one trial I was running, during the break, I sat in the witness seat to see what it felt like.
Yeah.
No one else was in the courtroom at the time,
Yeah.
and it was terrifying to be sitting there,
I bet it was.
even with
Yeah.
no one else in the courtroom.
Yeah.
So I think that idea of giving evidence for many people is hugely stressful.
Yeah.
Yeah.
And it's insightful of you to raise that point, because it's something people forget about. I think we all have different tolerances for stress.
Yeah.
Personally, I'm quite a cautious individual. I don't like having unknowns around me, and the idea of having a case hanging over my head for years
Yeah.
would cause me a lot of stress. I'd be thinking about it a lot, and this is what clients do. But it's not just the stress of giving evidence, it's the stress of the outcome. The outcome is unknown. There's this human factor in trials. Who's the judge? How will your witnesses come across on the day? Will the law change? Will the evidence change? You don't know. So the outcome's uncertain. The cost can be huge. You don't know what it's going to cost you, because a lot of that depends on how your opponents are going to react to your case. Are they going to cause you a lot of fees by taking steps that force you to spend more?
Yeah.
Yeah.
So it's hugely stressful, and when businesses and individuals are assessing their case, they're not just looking at how strong is my case? They're also looking at, would I rather spend this money elsewhere?
Yes.
Absolutely.
Would I rather spend the next few weekends with my family rather
Yes.
than writing a brief of evidence? So
Absolutely.
it all comes into it.
So the answer is really to mediate if there's any opportunity
Of
to
course,
do so, really.
yes.
Yeah.
No, I think it is it's the obvious option. I mean, there are cases where it might not work. Allegations of fraud, that sort of thing. In particular, I mean, I have run some fraud cases, and one of them was a land transfer fraud where a pensioners had lost the title to their home. They'd entered an investment scheme, signed a document which they thought would give them a small amount of income each week.
Right.
It turned out what they signed was a memorandum of transfer, handing their title over to some people they didn't know.
Crikey.
Wow.
They then mortgaged the house, the title to the
Yeah.
hilt. And so the claim was against the Registrar General of Land, but we had to sue the fraudsters first to
Yeah.
establish the fraud,
Wow.
which was a 3-week trial.
Yes.
And then we sued the Registrar General of Land.
Yeah.
So that's a case that could not possibly have been mediated
Yes.
either with the fraudsters or the Registrar General.
Was there a solicitor to be sued somewhere in there as well?
There was,
Yeah.
but the solicitor was one of the defendants, and the claim was
Right.
unsuccessful against the solicitor. So that's the
Yeah.
other thing in frauds. They're very expensive. Fraudsters generally by nature don't leave a trail of documents. You
Yeah.
don't quite know who
Yeah.
did what wrong.
It's a forensic
Yeah.
examination.
That's right. So there were
isn't it?
7 defendants in that case.
Yeah.
Oh, goodness
Yeah.
me. So we've got mediation and we've got court. And I know of another potentially helpful avenue to help businesses resolve disputes, and that's arbitration. Can you
That's
talk
right.
to us a little bit about arbitration?
Okay. So arbitration is it's a procedure whereby a dispute is submitted to an arbitrator or multiple arbitrators to make a final decision. So it might help to understand the distinction with mediation. Mediation is a voluntary process whereby you agree to settle. The mediator does not make a decision. The mediator facilitates your settlement. In an arbitration, it's basically like a private court case. So you appoint a private arbitrator. It's held in a private area, not in a courtroom. And a decision, it's called an award, is issued, which is like a judgment. And so that is another option.
Sounds cheaper.
Yeah, it is. It's cheaper. I mean, there are a number of distinctions with the courtroom process. So the first is you get to select your arbitrator. In New Zealand, there are a range of retired High Court judges and Court of Appeal judges. There are also people like myself, experienced barristers who do it. So you can select one of those, particularly if you've got a case where you need a specialty. So if you go off to a court, the judge is assigned and may not necessarily have the specialty you need.
Yes.
And one example would be construction disputes. So it's quite a specific area, and there are arbitrators who deal specifically with those. So you're probably better off to go one of them. The other aspect of arbitration is it's private and it's confidential. And I think this is a huge benefit for commercial parties. So if you go to court, there is a rule of a general principle of open justice. Members of the public can come in and watch.
Yes.
When the judgment is published, the public can see that judgment. And that has its place in society at cases. But the arbitration is private. And you can keep your affairs private. No one's allowed into that private room to watch it. And so some would consider that a benefit. The other benefit, now with an arbitration, it's only in very rare circumstances you can appeal. So the default position is that you can appeal only on points of law and only with the leave of the High Court. So you'd have to ask the High Court for leave to appeal. Having finality, I think, is just as important as anything else, and you're likely to get that with arbitration.
And quite often, you see cases that settle for a figure that is a mere sum of what the actual value of the claim is, purely for the benefit that it is an early settlement. You're insuring yourself from the risk that a judge might decide against you, aren't you?
That's right. You've touched upon an important point, which is litigation risk. And it's also harking back to something you said about clients who come in with a really strong claim. The litigation risk exists in every civil case, and no matter how strong your claim is, there is always an appreciable risk that you might lose, and it does happen.
Yes.
You could win on appeal, but then by that time you've spent so much in legal costs, it might not be worth it. The reason that there is that litigation risk is judges are human.
Yeah.
They will
Yeah.
take a different view of the law, and you see it all the time. You'll see a High Court judgment reversed by the Court of Appeal, the Court of Appeal reversed by the Supreme Court. So it's very difficult to tell your client you will definitely win. I'd say the best you could ever hope for is a 70% chance of success
Yeah, right.
on your strongest day.
Yeah.
And I think you should always look at mediation settlement.
Yeah.
Right. So if you can walk away with, is there a rule of thumb that you can sort of use to say, well, are you better off just taking 50% and moving on?
I don't know if, I mean, that would be one way to do it.
Yeah. That's the way I do it.
I think it depends. I think it depends what the amount is and what you personally can afford.
Yeah.
I mean, there are situations where there is no defence to the claim, and the opponent does have money and they just don't want to pay.
Yes.
And if it's a sizable amount, you might as well just pursue it. And there's a process called summary judgment.
Yeah.
And that is a short form trial. So the type of trial have been talking about at this point is where defences are filed and you go off to a hearing and you hear witnesses and the judge listens to the witnesses, the cross-examination, and hears argument. There's a shorter form version of that. It's called summary judgment. And it's, for example, a debt situation where there is no defence.
Yeah.
You've sold them a tractor and they haven't paid you for it. They owe you $300,000. Or even in the landlord case you're talking about where you're owed rent money. So what you can do is you can use a short form procedure. You go off to court, you file your statement of claim and an affidavit in support, and you seek a summary judgment against the defendant. And it will be a lot cheaper than the trial. Might cost you, again, this is just ballpark figures. Usually they'll only run for half a day or a day, but because you have to draft a statement of claim and the affidavit and the submissions, could cost you $30,000 to $50,000. But again, a lot less than the trial. So you don't necessarily always have to settle, but those summary judgments are only when there is no defence.
Yeah.
And people always will pretend there's a defence, but we all know whether it's a realistic one or not.
Yes. Yeah.
And it's really where there's no realistic chance of success of the defence.
Yes.
It's in those other cases where there is some defence, ambiguity in the contract, different interpretations, or maybe it's negligence and was it negligent or not. It's in those cases where you really start looking at what is the likely outcome, what are my likely costs, and you really need to do those calculations and spend a lot of time on them.
Sometimes what I've seen too is people struggle to make decisions on the margin. There's a sunk cost fallacy. I'm already into this 50 grand. What's another 50 grand? What's another 100 grand? And all of a sudden, you're $500,000 deep.
That's right, and it happens like that.
Yeah.
And people have pursue cases out of principle.
Yeah.
And they let the barrister know that. But when the final bill comes, it'd be amazing how the principles can drop away. You know, I think that it's in all of our interests in the commercial world to always be pragmatic and to always realise that there are going to be some losses in business.
Yes.
And you may not have got, you may have only recovered 20 or 30%, but that's money you can apply to your business and move forward.
Yes.
And plus you've added time to your day, to your year, you've removed stress from your life. The other thing people don't realise is, the huge distraction litigation is. Your lawyers will be spending a lot of time with you, getting your evidence, briefing you, getting documents. I mean, there's a lot better things you can do with your business than to spend them with your lawyer discussing litigation.
It's a lot of money spent on fighting principle.
Yeah. However, some people do love litigation. I do know people like that. And
I talked about Bob Jones earlier.
Yeah, that's right. He's had some really good skirmishes over the years. And yes, I mean, litigation can pay from time to time. And, there are people who buy other people's debts or litigation because they've got the funding to do it themselves.
Yes.
We have in New Zealand now litigation funders.
Yep.
So if you've got a juicy claim, which with good chances of success, you could get that funded by a litigation funder.
Yes.
Yeah.
Yeah.
Yeah. Because that wasn't always the case, was it? There's various rules that
That's right.
Champery, is it?
Yeah, that's right. It's called Shampity.
Shampity.
Yeah, that's right.
We'll get that later.
So there's still discussion around
Yeah.
that, but
Yeah.
what is known is that litigation funders are present in New Zealand, and it's working well,
Yeah.
and it's a good addition to the system.
Yes. Yeah. Yeah.
We need precedent. We
That's
need,
right.
you know, like lawyers that love precedent.
They do, yeah.
You know, and I think that, like, you know, you touched on points before around open justice and interpreting, you know, Parliament's kind of ways and having structure, because it provides that certainty for businesses to rely on, doesn't it?
It does, yeah.
Yeah.
I mean, that certainty is important. You know, if when a judgment comes out, well, you know, a very important one came out in the insolvency field. I don't know if you remember it, but it was to do with avoidable transactions. The point that went all the way to the Supreme Court was a defence. So, avoidable transaction, what that is a company's insolvent, and the liquidator can look at any transactions the company entered into 6 months before the liquidation, and then can claw back those transactions. So the period used to be 2 years. It's recently been amended to 6 months, but they can go beyond the 6 months if it's a related party. And so there is a defence to that, and that is that if you gave that in entering the transaction or receiving the money from the company, you acted in good faith, you didn't suspect they were insolvent, and you gave value for the transaction. And what that entire case rested on is, at what date did you have to give value for the transaction? And did it have to be contemporaneous with the payment of the money, or could it be early or later? And so the Fences and Curb case resolved that point, and it resolved it in favour of the creditors, and it said that the point in time could be at a different point in time from the transaction itself.
Yes. Yeah.
So that was an important case,
Yeah.
really important for the way we do business in New Zealand,
Yeah.
because it is a minefield when you are in a commercial relationship with a company that has become insolvent.
Yeah.
Suddenly you'll be questioning any payments you receive within 6 months. But also equally, you know, we're in a difficult financial economic period,
Yes.
and we also need an economic climate where businesses are comfortable to do business with other companies,
That's
even
right.
if they may be struggling.
Yeah.
Because if you stop doing business with them, they will go down, and that's not good for the economy.
Yes.
So that was a very important case,
Yeah.
and that's why precedent is important.
Yeah. Absolutely.
And I suppose one of the aspects of arbitration is that the awards are not published; they're kept private. That can be excellent for the parties, but you don't have that precedent flowing from it.
Yes. Yeah. Yeah. So, just in terms of the way that a business or a person, an individual would approach a dispute, we talked about the different forums. There's mediation, there's arbitration, and then going to court is the last step. So, at what stage should people engage a lawyer? How should they decide how to select a lawyer? Which lawyer should they select? And what's the best way of approaching those sort of questions?
Well, I mean, of course, I'm biased on this, but I think they should select a lawyer or engage a lawyer as soon as possible if they're clear that there is a dispute.
Yeah.
And one of the reasons for that is, even if your lawyer is in the background, the lawyer can help you not say or write something that might damage your case down the track. So it may be advisable at an early stage of dispute for the client not to put the lawyer forefront, because that might actually cause the parties to polarize. But it would be wise at least to have the lawyer in the background.
Yeah.
Absolutely.
And in terms of if you do go to mediation, you're actually a mediator and an arbitrator yourself.
Right, yes.
That's right. So at what stage would you look at finding a mediator? Is that something that's decided between the parties early on?
I think it depends on the dispute. Some disputes, you basically know each other's position relatively quickly.
Yeah.
Now, there might be a single issue, a single contract, a single dispute. not much is going to be added to that once you've filed your proceedings and done all of that. So, for example, I acted for a client where we went to mediation. They were going to be the plaintiff suing the other side, but we went to mediation before filing a proceeding in court.
Yeah.
It was to do with the licensing of plastic molds, and that settled at mediation. So by not filing the proceedings and going to court, the client managed to avoid tens of thousands of dollars of expense. Now, there'll be other cases where it would be a waste of money to go to mediation before the proceeding is filed,
Right.
because the issues have not crystallized, they're not known,
Yeah.
and I think it would be difficult for the parties to actually get to a point where they agree they've settled things properly between themselves. So there are some disputes where you need a bit more detail, a bit more knowledge before the parties can meet
Yes.
to resolve it.
Yeah. I suppose also by filing, you're showing that you're really serious. You're going to
That's right.
You're going to take this all the way if necessary.
Yeah.
And that puts the other party on notice that they need to resolve it. Otherwise, things could get a lot worse for them.
Yeah, I mean, that's a good point. A lot of defendants just don't engage and don't take you seriously. And so that sort of defendant, it would be better to file proceedings.
Because of course at that stage mediation's voluntary, so you
That's right.
prepare for mediation and then the others, they just go off for a coffee because they can't be bothered with it anymore.
That's right.
Does that happen though? Yeah.
Yes, well, I have had, mediation is voluntary and you can leave at any time you like. I've had a mediation where one of the parties walked away within the first 45 minutes.
Yeah.
And then they eventually lost at the trial.
Right. Yeah.
Yeah.
And that would possibly come into cost considerations as well, that they.
No, I mean, mediation is always split 50-50.
Yeah.
The outcome of mediation is confidential. I suppose I should mention that. One of the beauties of mediation and why it's so good is because it is all confidential.
Yeah.
You can be more open with each other about your cases.
Yes.
You can accept weaknesses if that's going to open up the channel of communication between the parties, and it's all absolutely confidential. But it wouldn't, in terms of walking away from the mediation, I don't think that would impact costs later on.
Right.
But what you could do to impact costs later on would be, for example, to issue a Calder Bank letter. So that is a letter to the other side where you, and it's usually described as without prejudice, save as to costs. And you make an offer to the other side for a certain monetary amount. And if they reject that and it goes to court, and the judgment amount that they receive is less than your offer or the same as your offer, then you have a good case to argue for indemnity for your legal costs, which is a big factor.
So depending on what sort of matter is, the earlier that you make the Calder Bank offer, the better, or is it?
Yeah, I've done one recently. I find the Calder Bank offer is good at a point when you know your case, you've got sufficient reasoning to put in the letter, to explain the offer, give the basis for it, and that it makes sense.
Yeah.
If you can do that as early on as possible, it is a good thing, because it means that you've got a good chance that all of your legal costs from that point forward, or most of them, will be covered if you win at trial.
Yeah.
Well, this has been really great, Damian, to have you here.
Oh,
and
thank you.
Hearing about some of your stories, and you're working as you're taking instructions up in Auckland, but you're also taking instructions down in the lower South Island.
That's right.
Queenstown.
I am.
Yeah. So how do people get in touch with you?
Well, I'm at a chambers in Auckland, which is called 48 Shortland Chambers. And my email is there on the website, and my profile's there as well.
Awesome. Will you be coming back for some skiing?
Well, I'm moving to Arrowtown in late June, and I'll be living there for 4 months.
Yeah.
So I will. My plan at this stage is to get up, feed the dog, take the dog for a walk, and then have a ski every morning before I start work.
It's a good option.
Work-life balance.
Yeah.
Yeah,
That's what it's like living in Queenstown.
Yeah.
You know, Queenstown's such
Well,
a
I
great
mean,
place to live.
Coronet's only a 20-minute drive,
Yeah,
and
yeah.
should be able to be at my work desk by 9:30, I think. 10.
Yeah.
Good stuff. No, thanks for sharing your knowledge. It's been most
Oh, thank
useful,
you.
and no doubt businesses in Queenstown will just lap up what you've got to say. So
Thank you.
Cheers.
Well, thank you very much for joining us for another episode of Off the Record. Catch you next time.
Thanks. Bye.